In this installment of our discussion of school law and policy, we're going to talk about desegregation. Racial segregation sanctioned by law persisted until the mid-1950s and early 1960s in places in Western Kentucky like Owensboro, Elizabethtown, Bowling Green. Segregated schools were a part of the fabric of these communities. When the courts took the position that the separation of children based on race was unconstitutional and unacceptable, things began to change. In 1954, the U.S. Supreme Court, in its landmark Brown versus the Board of Education of Topeka, Kansas, probably the most famous education law case, overturned an earlier Supreme Court ruling from 1896, Plessy versus Ferguson, in which the court held that separate but equal was acceptable, when in reality, separate facilities for minorities were not equal to those for non-minorities. This all changed in 1954 in Brown. The Brown decision shone a light on the idea of de jure segregation. De jure segregation is segregation that's sanctioned by law, as was in the case of Brown 1, because equal protection under the law essentially covers state action. It prohibits state-endorsed discrimination. As we'll see, some of the cases that follow became leading cases in defining the scope of the duty to eliminate de jure segregation. Those cases are part of the Brown 2 decisions. But first, let's look at Brown versus the Board of Education. There were 4 cases, one from Kansas, one from South Carolina, one from Virginia, one from Delaware. They were consolidated and decided in the Brown decision. Each case, Black students sought admission to segregated schools in their communities. The Kansas permitted but did not require segregated schools. So Kansas was looked at as one that was the best test case to send this to the Supreme Court. The 4 states relied on separate but equal decision in Plessy versus Ferguson to defend their positions. The U.S. Supreme Court disagreed and held that schools should be integrated. Students cannot be discriminated against in their attempts to attend school on the basis of race. The 14th Amendment guarantees the equal protection under the law for students attending public schools. Segregation sanctioned by a state deprives minority children educational opportunities. Separate but equal schools based on race are inherently unequal and unconstitutional. So the Brown 2 decisions led to a whole piece of how to ensure the proper implementation of the Brown decision, Brown 1 as it's called. Brown 2's ruling was fashioned to ensure this implementation. These cases were remanded to federal district courts based on their proximity to the local school districts in play. This ruling mandated that school authorities be delegated the authority to implement its ruling in good faith with all deliberate speed. So the emphasis here in the ruling Brown 2 was handed down as a means of expediting the ruling of Brown 1. Brown 2 remanded desegregation cases to federal district courts because of their close proximity. And these cases held that school authorities were the ones primarily responsible for implementing the ruling in good faith with deliberate speed. Each district was provided some consideration when reviewing their plans to consider problems relating to administration, transportation, personnel, and other issues that might arise during this transition to a non-discriminatory school system. District courts were given the task of supervising the transition from dual segregated systems, to a unitary desegregated school system. It's fascinating in cities like Owensboro and Bowling Green especially to look at how the desegregation process happened. And we're kind of in the process of losing this generation. So having discussions with people like that, I think, are very unique opportunities to have. Some of the follow-up cases, the Swan case out of Charlotte, North Carolina, the court imposed a plan to eliminate segregated schools after the school board failed to do so, because many states just flat refused to accept the Brown decision. So some of these follow-up cases really became significant. But the other piece that's important to understand is that also began to significantly weaken some of the points of desegregation because of the challenge politically. The district in Charlotte-Mecklenburg County was comprised of 75% white student body and a 29% Black, and that remained segregated in spite of a 1965 plan to desegregate that failed. Swan was a leading case that defined the scope of duty to eliminate de jure segregation in a dual system with a Black and a white set of schools. The objective in Swan was to ensure that school authorities excluded no student of racial minority away from school directly or indirectly based on race. The use of mathematical ratios was only a beginning point in the process of shaping a remedy for eradicating segregated schools. If an optional majority to minority transfer provision was implemented, transferring students were granted free transportation and thus began the busing discussions. Pairing or grouping non-contiguous school zones was permissible and considered in light of objectives sought by the school district, and that's very complicated in large metropolitan regions like Charlotte or Louisville, which had a whole host of problems, as we'll see. An objection to transportation of students is valid when time and distance of travel is so great as to either risk the health of children or significantly impinge on the educational process. A lot of the cases that followed subsequently were cases that really looked at large metropolitan regions like Detroit. In the Milliken v. Bradley decision, you began to see the establishment of different independent districts in the suburbs that circumvented the desegregation of the Detroit public schools. And the court in Milliken was asked to determine if all of those independent little enclave school districts should be considered as one part of Wayne County in Detroit, and the court denied that request. And so Milliken v. Bradley was a step back that allowed schools and school districts in the suburbs to essentially act independently and create sort of a hodgepodge of segregation that was legal. And that really derailed much of the Brown decision. One of the other big questions that was considered was the free transfer and freedom of choice, although some courts concluded that free transfers and freedom of choice plans were not effective in eradicating segregated schools. Many districts embraced those plans. The implementation of free transfers led to students being transferred to racially identifiable schools. Consequently, school officials were unable to avoid court-ordered desegregation by merely allowing students to choose a school they wished to attend. This was the case in the Greene v. County Board in Virginia case. It arose when the school board devised a plan to allow students to choose between two schools, one predominantly Black and the other predominantly white. The plan was essentially a freedom of choice plan. The students who did not choose were sent back to school they previously attended. During 3 years of implementations, no whites chose to attend the Black school, and roughly 115 Blacks opted to attend the white school. Approximately 85% of the Black students still attended the all-Black school, and the effectiveness of this plan was challenged. The court held that the plan was ineffective in achieving desegregated school system and mandated that an effective plan be devised. A freedom of choice plan offers little promise in a district with long history of segregated schools. The 14th Amendment, as interpreted in the Brown decision, requires schools be desegregated. Ineffective plans are intolerable and create delay in implementing the Brown decisions. That was the case here. Effective plans had to be devised immediately so that the 14th Amendment requirement of equal protection under the law for Black students could become a reality. Now we get into some of the issues around de facto segregation. De facto segregation is present when there's a substantial number of students enrolled in a school and it represents a racial ethnic minority. But they are not there legally, they are there de facto, not by the law. This situation developed through no action taken by the school district. The courts did, however, mandate the corrective action be taken in instances where school officials gerrymandered, altered school attendance zones to create zones with large concentrations of Black students assigned to historically Black schools within the district. An example of false de facto segregation emerged in New Rochelle, New York, and there is some really, really interesting segregation, housing, and school issues from New Rochelle, New York, north of the city, New York City. The Board of Education there realigned several school attendance boundaries and permitted transfer only to white students who lived within the boundaries of schools in question. Approximately 90% of the students attending the school were Black. In a ruling against the plan, the Second Circuit Court summarized the board's intention was to create a substantially segregated school, again, to do an end around of Brown. When school officials failed to devise and implement a plan to eradicate state-imposed segregation, the district courts have the discretion to fashion a remedy and eliminate segregated schools. When school officials fail in their obligation to create proper remedies to remove segregated schools, they're in violation of the 14th Amendment's Equal Protection Clause. District courts altered attendance zones and devised zones based on grouping and pairing of schools that required busing to achieve desegregation. The district courts also disallowed patterns of school construction and abandonment that created a dual system of segregated schools. Plans devised that result in substantially segregated schools like this are illegal. Conduct on the part of the school board that is designed to create, maintain segregated schools clearly violated the 14th Amendment and the Brown holding. And so the New Rochelle case was an example of the contentiousness that in many ways still exists around this issue today. Busing issues are also really significant issues in many parts of the country where federal courts were challenged when their rulings called for busing to remedy segregated schools. The courts historically viewed busing as an effective means of achieving desegregated schools, although it's been opposed by parents and citizens. Those who oppose busing say it threatened the neighborhood school concept, which it did. It led to a length of time consumed in transporting students great distances to attend schools out of their neighborhoods, and it was expensive. Not to mention that it led to consistent political issues. In spite of the objections, however, the courts continued to rule that busing be used as a means of achieving desegregated schools. And of course, there are several cases, one in Seattle and multiple others, where desegregated plans called for extensive use of busing. In many cases, the people in those communities took that to courts. And in many cases, the Supreme Court and other courts held for the plaintiffs to back down on the busing. And so there really was not ever a racial balance that ended up being permissible or a mechanism to reach that balance. And that's one of the challenges as we see Brown unfold and interpreted around the country by different courts and even in the Supreme Court. Of course, one of the other issues takes place in Louisville with the Jefferson County Public Schools and the issue of student choice around their mechanism for creating magnet programs as an option for desegregation. That was struck down as well. And so the Brown decision and the fallout from the Brown decision really has crept back toward no real effective mechanism. And schools today in many parts of the country are still very highly racially segregated. And so the ultimate question really with Brown is how do you do it effectively and how do you reach a consensus that is applicable to all members of the community appropriately without the racial bias that has seemed to leak into every decision in one form or another. And so let's move to the diversity piece, particularly on the language side, with many students who are Latinx and Hispanic and Latino. Many of these students face language barriers that often affect their ability to reach academic potential. And public schools also have an obligation as far as dealing with segregation issues in addressing language barriers for non-English speaking students. Since Spanish-speaking students represent one of the fastest growing populations in the country, public school officials have to figure out how to meet their needs, and Latino and Hispanic and Spanish-speaking students contribute to a racially diverse environment in schools, and receiving equal education opportunities to learn is also very challenging on that front. One of the important cases to look at that we are reading is the Lau v. Nichols case, and it's an early case involving non-English speaking students. That the U.S. Supreme Court held that the San Francisco schools failed to make provisions for non-English speaking students in violation of their equal protection rights under the Fourth Amendment, as well as with Title VI, based on the absence of appropriate English instruction. And the points of emphasis in this case is the equality of treatment was not achieved simply by providing non-English speaking students the same facilities, curriculum, teachers, and textbooks. Requiring students to acquire English skills on their own before they aspire to progress in school constitutes a breach of public education trust. And basic English skills are at the core of what is taught in public schools. So students who do not have mastery in English are effectively denied the equal opportunity to learn. And so this is really an important piece that leads the way to a lot of the ELL instruction in schools as well. Complicated issues, ones that really need to be continually discussed and continually on the mind of people that work in school leadership, district level leadership as well.